Yeah, and I believe I think the timelines are also very, very important as far as mediation proceedings are concerned. Unlike courts, where of course all timelines are recommendatory and never mandatory, but here also certain timelines have been provided. So if you would like to articulate.
Yes. The timelines are 120 days plus 60 days. So 120 days is the time that has been given during which the mediation has to finish. And 60 days is the time that can be extended if both the parties agree.
You're right. So which is quite fast, 4 months for a settlement or the following 2 months. So at the outside 6 months for a settlement.
Yes.
What if the settlement fails, Varun? Timelines are good, settlements are good, but since everything is happening with the consent of both the parties, and these are the parties who are sort of fighting. So when parties fight, where is the consent? So what happens if the mediation agreements or sort of not agreements where the mediation fails per se?
Sumit, it's a method of resolving dispute in an alternative way, because it's an ADR, right? So if the parties fail to resolve their dispute through mediation, then they will have to go to the courts, or as we discussed earlier, if they have arbitration in their agreement, then they'll go for arbitration.
Right.
If the mediation fails, then as per the act, the mediator has to submit a non-settlement proposal with the council or the mediation service provider. But that's a procedural thing. In general, if the parties fail to reach at an amicable solution through mediation, then they will have to resort to the regular jurisdiction of the court and the regular process of the court through CPC or any other specific dispute is.
Either the arbitration or the court, as the case may be. Yeah. Understand. And mediated settlement agreement, you mentioned it can be the execution proceedings can be launched. For that, is it required to be registered somewhere?
It's not mandatory. It can be registered. It's not mandatory. However, the rules have yet to come. Section 20 talks about it. It says may at an option of parties be registered with an authority constituted under the said act. So the authority constituted under the said act will be the Mediation Council of India. But however, the rules are still not out, and it says it's not necessary, it's not mandatory that the mediated settlement agreements needs to be registered with the authority. Not necessary.
Right now, it doesn't look like, but as you rightly said, if the rules come out and some procedures are developed, and in case it emerges that registration is mandatory, let's see how the rules or the notifications come.
Yes.
Can mediation proceedings be challenged?
Mediation, the mediated settlement agreement arrived between the parties can be challenged on very limited grounds, like grounds of, I'll say, fraud, corruption, impersonation, or if the mediation was done for any kind of a dispute that has been barred under the first schedule. That's it. That's what the Section 28 states.
Yeah, so pretty much fraud and corruption are completely means outlier cases. So more like an undue what was that in the Indian Contract Act? Undue influence.
Undue influence.
So when the consent is not there by misrepresentation, under the Indian. So settlement agreement is also, it's like an agreement under the Indian Contract Act also. So I think those tenets of a contract have to be there. The consent has to be there, which is not obtained by fraud or undue influence or coercion, etc. I remember my law days 20 years back. And other than that, I think it's mostly maintainability to that extent, right? It means it can't be challenged on merits to that extent, what I'm hearing.
No, not at all. No. Merits, if parties once reach the settlement under the mediation and they sign the mediated settlement agreement, it becomes a judgment, as I stated earlier. It becomes a judgment under this act. So there are very, very limited grounds. And the grounds are, again, fraud, corruption, impersonation, or for the mediation for any dispute that has not been covered under that is not fit for mediation under first schedule of Section 6. Right. That's it. No merits.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.